So when we talk about essentials of tort, there are three essentials that we need, as in three things we need to prove or we need to have in order to constitute a tort, in order to claim for some kind of a relief, in order to go to the court. First is act or omission. Act or omission on the part of defendant. So there will be two parties in a case: plaintiff, who is going to the court filing the case, and there is defendant, who is the wrongdoer against whom case is filed. So we can file a case for tort only when this person, the defendant, has done something wrong. Okay, it may be by way of doing something, or it may be by way of not doing something. Okay, so what is act or omission? Act, we all know, right? Doing something, action, act, our action. I was not supposed to enter someone else's private premises, but I did enter. That is nothing but my act constituting a tort. But when we talk about omission, what does omission means? Omission is failure to do something wherein I had an obligation to do it. Okay, maybe if you talk about doctors, right? If you visit a doctor is supposed to do some basic tests in order to determine what is your problem, right? Doctor should not straight away operate you, right? Some basic things they would inquire. If they have failed to do that, if straight away a doctor starts operating a person, later it turns out the person was diabetic. In such a case, what happens? It is omission. Doctor had a duty to check medical history of the patient. Doctor failed to do it. So omission means we have a duty wherein we failed to perform our duty. Okay, so when we talk about the first essential, it may be act or omission. Either I was not supposed to do something, but I did it, or I had an obligation to do something and I failed to do it. Okay, relating to that, we have one case also. Glasgow Corporation versus Taylor. What happened here is there was a public park. Okay, public park was there, which was maintained by this corporation. Now, when you are maintaining a public park, you have a responsibility as well towards the public who will come to that park. What happened here is they failed to put proper fencing to keep children away from a poisonous tree. Within the public park, there was a poisonous tree and they failed to put proper fencing. For adults, it's fine. We know what all fruits or what all leaves we can eat, right? We would not randomly go to a park and start eating some fruits or berries that we do not know. But a child might not know it, right? So regarding this, they should have given proper fencing, which they failed, as in it was omission on the part of the corporation. And as a result, what happens? A child plucks and eats the fruits of that poisonous tree and then he dies. So in this case, the corporation was held liable because maintaining a park, they had an obligation to ensure safety of the public. They failed to do it. First of all, they kept one poisonous tree within the park, and second of all, they failed even to give proper fencing to keep children away. And as a result, a child died. So this is nothing but omission. Okay, that is the first essential which we need to prove.
The same will be applicable to the things which are causing accidents in the road and all. If like any garbage pit or something, if someone falls inside that, so the municipality or corporation will be responsible for that. Like that.
Yeah, see, again, that would depend, okay, whether municipal, like, was it possible for municipality or not? Because some random person might also throw garbage on the road. For that, you might not be able to make municipality liable. There was one case also, in fact, there was one like meat shop. Okay, it is said that if you do something just for once, it's usually not tort. Okay, it should be something which is continuing. So there was one meat shop, and from there a piece of fat, it escaped from the shop and it fell on the street. Okay, a person got injured and he filed a case to claim for compensation, and court did give him compensation. So in that case also you can say that it was a piece of fat which is like falling on the road, so might be it's municipality's responsibility. But no, it was considered that it was responsibility of the shopkeeper. So that again would depend on the situation. We cannot straight away say that okay, this is what is going to apply. But yes, act or omission should be there. Okay, and when we talk about responsibility of the municipality, there is this one more case. Okay, it is Municipal Corporation of Delhi versus Sobhagyavati. Now, what happened in this case is there was a clock tower. Okay, and this clock tower was set up by the MCD, Municipal Corporation of Delhi. And it was there in a very busy area, which is Chandni Chowk of Delhi. Now, when you set up a clock tower, you again have a responsibility to maintain it, to ensure safety of people, etc. Okay, so what happened here is this clock tower was there set up, and it was 80 years old clock tower. And normal life of such clock towers is 40 to 50 years. That means after 40 to 50 years, you either remove it or you replace it. But this clock tower was there, which was 80 years old. And one day it fell, one day it collapsed and it injured one person. Okay, so in this case, what happened is municipal corporation was having full responsibility to maintain it, because number of people died due to collapse of this clock tower. It was considered that MCD is responsible. If you are setting up a clock tower, you have a responsibility, you need to perform it properly. If you are not doing it, as in it is negligence on part of MCD. So they were held responsible in this case. So based on situation, we need to decide who was having responsibility at that specific point in time. Okay, we have a concept called occupier's liability. Whoever is having control of a certain premises, that person is considered responsible usually. So we need to look into the situation, the facts and circumstances of the case to fix the responsibility also. Okay, so this is the first essential that we need, act or omission. This is clear, right? Act or omission?
Yeah, clear, ma'am. Right now you said like occupational liability, right?
Sorry?
Right now you told a term occupational liability.
Yeah.
Okay.
Occupier's liability, as in whoever is occupying a certain premises, that person is having a responsibility. Okay, if you are owner of a certain shop, being owner or being manager, you have a responsibility. If you are owner of a college, being owner of the college, might be you are responsible. Or might be you have appointed a manager. In that case, even if you are owner, you are not responsible because you have given your responsibilities to the manager. Like that, we decide who will be responsible. Okay, now second essential is very much important, which is legal damage. Now, what is legal damage? It is very important concept and a little difficult also. Okay, so we need to see this carefully. So when we talk about damage, what is damage? Damage is nothing but injury or harm that is caused to a person, right? So when we talk about torts, we are not simply talking about the harm or loss, but rather we talk about legal damage, as in a loss or harm that you have suffered, but at the same time, it is recognized by law. As in, law says that yes, you have a right, your right is being violated. That is called as legal damage. Okay, so legal damage is also one of the essentials. If legal damage is not there, but simply damage is there, as in you have suffered a harm, but that harm is not recognized under law, there you are not entitled to any compensation.
Ma'am, can you please give me example for legal damage and which is not a legal damage?
Yes, I will give you example. There are actually two maxims explaining what is legal damage and what is simple damage. Okay, there you will get an idea. But what is essential? Legal damage is essential. So unless and until you can prove that, first of all, we had act or omission, right? So you need to prove that yes, act or omission was there, but whatever act or omission was there, it has resulted in legal damage. So what is legal damage? Legal damage means violation of a legal right. Okay, violation of a legal right. As in, you might not have suffered loss in terms of money, physical injury, harm to reputation, or something like that. Okay, you might not have suffered loss which you can show or prove. But what is important is your legal right is violated. Might be under some legislation you were given a right, that right has been violated. That is important. Okay, only in such a case we can file a case. Where there has been violation of legal right, it is actionable. You can go to the court and you can seek a remedy or a relief. Whether you have suffered some actual loss or not, that can be proved or that can be shown to a person. Okay, so what is important is that whether the defendant should or should not be held liable is, it is enough to see if legal right vested in the plaintiff has been violated or not. So when a case is filed, first of all, we need to see, is there an act or omission? Secondly, we need to see, has this act or omission resulted in violation of legal right or not? Okay, maybe I have a right that I can move freely. Okay, but what is happening? One person has locked me inside a room or maybe inside a house. In that case, my right to freely move has been affected, and that is nothing but legal damage, violation of a legal right. I can claim for compensation. All right. So in order to understand legal damage, we have two maxims: injuria sine damno, damnum sine injuria. These two maxims explain what is legal damage, in what cases we can claim for compensation, in what cases we cannot claim for compensation. So you can understand these two concepts by simply knowing the meaning of these three words. Damnum means damage or loss. This may be in terms of money, comfort, health, reputation, etc. Okay, sine means without. Injuria means infringement of a right conferred by law. So what does this first principle mean? It means that damage, as in some sort of a loss that you have suffered, maybe in terms of money, comfort, health, reputation, etc., without injury or damage, in which there is no infringement of a legal right which is vested to the plaintiff. As in, you have suffered some sort of a damage that you can prove before the court, but none of your legal right has been affected or violated. And because your legal right is not been violated, in these kind of cases, there is no action lies. As in, you do not have a right to go to the court. Fine, you might have suffered loss or damages, but your legal right is not been violated. So what is important is violation of legal right is important. Whether damage is caused or not, that is secondary. That is not that important. All right, so it might sound a little confusing. I will tell you about one case which will make it very clear. Okay, it is Gloucester Grammar School case. All right, now what happened in this case is that there was a school, okay, in a certain area called as Gloucester Grammar School. Now, this was the only school in that area. So a lot of students were going to the school and they were studying there. All right, there was a schoolmaster in that school who had good reputation with the students, as in students used to like that teacher a lot. Okay, but now he had some arguments with the management and he left the school. Okay, this schoolmaster who had good reputation with students, he left that school and he opened a rival school. Similar school he opened in the same area. Okay, and because students used to like him, a lot of students moved from the previous school to the new school. They took admission in the newly opened school, which was opened by the schoolmaster. Okay, as a result, what happened? This Gloucester Grammar School had to suffer heavy loss because half of their students were now gone to the new school, and whoever were remaining, to retain them, they had to reduce the school fee. Okay, so there was huge loss in terms of money that can be proved before the court also, right? Gloucester Grammar School went to the court and they said that because of this rival school coming up, we have suffered loss and we need compensation for it. But what did court say? Court said that yes, you have suffered loss in terms of money, but has your legal right been violated? Your legal right has not been violated, right? You have a right to set up a school and to maintain it and administer it. You are still doing it. But if you have a right to maintain a school, same right the schoolmaster is also having. So even though you have suffered loss in terms of money, and that was like a heavy loss, you do not have a right to claim compensation because your legal right was not been violated. Before also you were free to run your school, now also you are free to run your school. Just because of competition, there is no right that arises to claim for compensation. Okay, is it clear? This is a damage, but without violation of legal right. Is it clear or confusing?
Sorry, ma'am, I just need one clarity in this case. Nowadays, what we are seeing is in employment, if you take example of some managing director or somebody who is in that position, usually company will not allow that person to go out from that company and start similar kind of business. So that is also called as breach of contract, or I don't know the exact terminology, what it is called. If there is a contract between that person, MD, or between the company and the MD, saying that you should not leave the company and start similar kind of business during like say next 6 months or next 1 year.
Yeah.
In such cases, will this case law or the whatever you have mentioned, is that applicable or not applicable at all?
See, in those kind of cases, right, usually in the offer letter or in the joining letter, right, companies will put such kind of a clause, but duration is limited. It might be maximum like 2 years, not more than that. Okay, so there is not like a restriction for your lifetime that you cannot do it. All right, and that is done in order to protect their interest also, because they have invested their time, effort, energy, everything in order to build something. So somebody else should not simply come, learn it and copy paste it, right? That is why it has been put. So there is not like a lifetime restriction. That is why it is not like a violation of your legal right, but in order to protect their interest, they are putting a limited period restriction. Okay, or sometimes there may be restriction like you cannot join a rival company, otherwise some of your profits would go, like would be waived off and like that. So these are not like absolute restrictions, but restrictions in order to protect interest of the person. Okay, and in some cases, if the restriction is like, okay, fine, next 10-20 years you cannot do it or something like that, their person can challenge the validity of that contract itself in court. The person can say that this is like one-sided contract, and court can decide. Might be decision can come in favor of the employee also. Okay, some reasonable restriction is fine. That is needed in order to protect interest of the other person also. Okay.
Okay, so if it is of short duration, as you said, within 2 years, then it is acceptable by the court as well.
Yes, yes.
Okay. So, but if there are no such contracts entered between the parties, then not.
Yeah, then there is no restriction.
Okay.
Yeah. So next one is completely opposite to the previous one. Okay, what is it? It is injuria sine demnum. Injuria means infringement of a right conferred by law, like a legal right. Legal right to practice a profession, enter into a business or something like that. Okay, so there is injuria or there is infringement of a legal right. But it is without what? Without damage or loss in terms of money, comfort, health, etc. As in, your legal right has been violated, but without any sort of actual loss that you can prove before court or show to the other person. In the previous case, they could have given an estimate also of how much loss they have suffered. Gloucester Grammar School case. But here what happens is you cannot show it in terms of loss. Okay, or might be you have not suffered any actual loss, but what has happened is your legal right has been violated, and that is important. Okay, so even though you do not have any actual loss to be proved before the court, you can still file a case and claim for compensation because your legal right was violated. Okay, we will see one example for this. It is AIBE versus White. There was one case. Okay, AIBE versus White. What happened here is, you might have noticed, right, during elections, government employees would be appointed in order to take care of all the election matters, right? They from different departments, they will come and they will do it, right? So there will be a lot of different government employees, but one person will be the main person. Okay, he is called as presiding officer, and he will take care of every single thing, right? So what happened in this case, AIBE versus White, is there was one person who was a qualified voter, as in he was the person who was entitled to give his vote. And before going to give his vote, he decided also that this is the candidate for whom I want to vote because I want him to win the election. Okay, so what was the purpose or what was the motive of giving his vote? He wanted a certain candidate to win the election. He went there, but he was restricted by the returning officer or the presiding officer because there was some misunderstanding. Okay, the presiding officer thought that maybe he is not a qualified voter, so he was prevented that you are not qualified, you cannot give his vote, and he was finally not allowed to give his vote. Okay, so voting is what? It is a legal right, right? We have a right to vote, and that right was being violated. That right was being violated by the presiding officer. So what happened in this case is, his legal right has been violated. He had a right to vote. That right was not given to him. But if we look at any actual damage, he has not suffered any actual damage because the candidate for whom he wanted to vote, right, that candidate anyways won the election. So in reality, it does not matter, right? Whether you gave your vote or not, that does not matter. The candidate anyways won the election, and that's what you wanted. So there is no loss or damage that you can show, but yes, your legal right was been violated. So in this case, the person was given compensation because his legal right was been violated. It does not matter whether he has suffered any actual loss or not. Whether that one single vote counted or not, that does not matter. What matters is his legal right was been violated. Okay, is it clear?
Yes.
Yeah, clear, ma'am. Ma'am, one more doubt. If someone is like, the situation is like, if someone is prevented from entering the examination hall for an university exam, so will it come under this one, or how it will come? Like,
but like depends on why he was prevented. There are some rules and regulations, might be he has not followed it. In that case, it would not be applicable because he has violated the bylaws of the university or the college itself. Okay, but if it was that by mistake or willfully he was prevented, where he had a right to appear for the exam, in that case, yes, he can claim that, yeah, I had a right to appear for the exam, but I was prevented without a valid reason. There he might claim for it. But usually it happens that maybe student was not having minimum attendance, or he had violated some bylaws or something like that. So there it would not be applicable because he himself violated the laws. Okay.
Okay.
So these are the differences between these two concepts. You can simply read this part and you will be able to recall it. So damnum sine injuria, wherein damage or loss is caused without violation of legal right. Because legal right is not been violated, it is not actionable. You do not have a right to seek legal relief. You do not have a right to claim for compensation or other reliefs from court. Case is Gloucester Grammar School case, which is also known as rival school case. Injuria sine damnum means infringement of a legal right is there, but no actual harm is being caused. You have not suffered any actual harm, but yes, your legal right has been violated. Because your legal right is violated, you have a legal relief available. You can go to the court and seek compensation or other reliefs that is there. Okay, case is AIBE versus White, right to vote case. Because a qualified voter was not allowed to vote, he was considered entitled to compensation, even though the candidate for whom he wanted to vote won the election. Okay, there is one similar case, Vim Singh MLA versus State of Jammu and Kashmir. In this case, what happened, right? This state legislative assemblies, they will have their assembly sessions during a certain point of time, right? They would have a fixed timing. Within that, they would have the assembly session. So Bhim Singh was an MLA and he wanted to attend those assembly sessions. But what happened is, while going to the assembly session, right, he was wrongfully arrested and he was kept in jail for this entire duration until this assembly was over, right? For this entire duration, he was kept in prison. So he, being a qualified person to attend the assembly session, he was not allowed to do it. He was not allowed to attend the session. Okay, so he filed the case after he was released, and he was also considered entitled to compensation. So I think some 50,000 compensation was given to him because he was a qualified person to attend the assembly session and he was prevented from doing that, as in his legal right was been violated. That is nothing but injuria sine damnum. Okay, injury or infringement of a legal right, but without actual harm that you can show before the court. And last one is legal remedy. So first of all, there should be act or omission. Secondly, it must result in violation of a legal right. And thirdly, there has to be a legal remedy. Whenever you see a legislation, right, if a right has been given, it will also talk about a remedy. What will happen in case your right is violated? It will always mention that, and that is nothing but legal remedy, a remedy or relief that is available under law. Okay, so whatever act or omission is there, it must give rise to a legal remedy. As in, we have fundamental rights. And Constitution itself says, if your fundamental rights are violated, you can go to the court and you can file a writ petition directly in Supreme Court or High Court. As in, what is it? It is nothing but a legal remedy. Same ways for other different legislations also, you will see that if this certain thing is done, it is considered as a crime. If this crime happens, you can go to the magistrate court or sessions court, file a case, and the criminal will be punished. This is nothing but a legal remedy. Okay, so we must have a legal remedy available. Only in such a case, we can go to the court for violation of our legal rights. So these are the three things which we need to prove before court while filing a case. Okay, act or omission, legal damage must be there, and legal remedy should be there. 3 essentials in order to constitute a tort. This part is clear, right?
Ma'am, just one doubt.
Yeah.
When there is a legal remedy, will there be any cases where when there is a legal damage, will there be any cases of where legal remedy is not available?
Yeah, that only. It is not possible. Okay, there is one concept also. UB just EB remedium. It means when there is a right, there will be a duty. Okay, it's not that simply a right will be given, because we all have a tendency of trying to break the rules. So whenever a right has been given, they will fix a duty on somebody else, and they will also mention that this is the remedy available. Simply a right will not be given in none of the legislations. Okay, a duty will also be fixed. Who is having a duty to ensure we are able to enjoy our rights, and also it will provide for a remedy. Okay, because otherwise rights would be meaningless. Simply saying, okay, you have a right to do this, but then no remedy available. That would be meaningless otherwise. So you would get a legal remedy as well.
Okay.